decide the appeal that was filed by the Cornwall Inn. We've had a couple of public hearings, and now it's time to get down to business. Let's see. We don't need to see any alternates, do we? No, I guess not. So, we have a full roll, and we have one alternate here. Alternates will be allowed to participate in the discussion, but obviously can't vote. The issue remains the same as it has been during the course of this, is whether or not the zoning enforcement officer erred when she rendered her decision that's been appealed from. I want to kick off the discussion, if you don't mind. A few thoughts about some of about the issue and the case before us. And I just want to point out at the outset that the CEO, Karen's attorney, has said that the definition of family is critical to our decision tonight. I myself, I mean, I could be wrong, I'm open for discussion. I just really don't see that, how a definition of family will enter into what we decide tonight. Oh, yeah, there's one thing I forgot to say. The state law requires that I remind any member here who has a direct or an indirect, either personal or financial interest in the outcome of this matter, needs to recuse herself from this matter. So I guess I'm asking, does anybody here have such an interest that feels that you need to disqualify? Okay. Well then.
Don, do you feel that Nancy's statement, which was made before the public hearing was closed, would in any way endanger the appeal of any decision that this group makes?
It's not up to me to ask someone to recuse herself. You asked me for my personal opinion? No, I don't.
We have had the bed and breakfast closed 2 years this January, so I have no financial interest whatsoever. I do have experience in this area, but I have no financial interest.
But you did make a statement with your point of view prior to the hearing closing. So I'm not disagreeing with what you said. I'm asking whether your having made a statement prior to the hearing closing would endanger the decision of this commission.
I don't think I really said one way or another. I think I brought up some points of view. I don't think I said what my final decision would be. I think I did discuss some issues that I thought about.
Okay.
Now, I'm proud to be saying some things that you all know already, but I think we need to draw our attention to some things. And one of the first is that our zoning regs are permissive. They're unlike other regs in other places, unlike even the U.S. Constitution. If a use is not clearly permitted in this town, then it's prohibited. And since the regs are silent, that's the short-term rentals, other than bed and breakfast, which are pretty clearly delineated and defined, they on the face aren't allowed.
Short-term, you mean what?
Well, that's one thing, they don't really define short-term. But there are other, that said, there are other terms such as accessory uses, customary and incidental uses that we need to discuss in relative to short-term rentals or any other use. We get the benefit of getting a couple of memos from our counsel, Attorney Grimes, about this entire matter, which you have in your packets. And Attorney Grimes is here, so if you have any questions on those memos or those points of law, you can ask him those questions. Now the use, there are the primary uses and other uses that have a reasonable relationship, and whether that's our job is to figure out if these reasonable relationships are they related to the primary use, and whether it's usual in Cornwall to maintain the use in question in connection with the primary use. And so I guess that, and then in addition to that, we have to determine, and one of the other things that would maybe allow the uses is to, almost like a past practice, whether the use is widespread, whether it's been in existence for a very long time, almost is to make it part of the regulation. And whether it's, I guess their words were commonly and habitually established as associated with the primary use. And when we think about commonly and habitually used, Cornwall's our universe. It doesn't matter what Ridgefield does. I know we have some things in the packet about what Ridgefield does or doesn't do. It doesn't matter what Goshen does. It matters what we do, what we've done. So we're comparing ourselves to ourselves. I know from experience that long-term rentals have been used in Cornwall, because a lot of people, including myself, came to Cornwall as renters and transitioned into home ownership. But I think a lot of those renters, it's not really what we're talking about. What the subject of this appeal is, when you rent to transition to home ownership, you're renting long-term. You may, and I think you mostly do, even if you have a year lease, you mostly, I think, pay your rent on a monthly basis. And that, to my mind, kind of establishes a month-to-month use as being acceptable. I don't know if, and that's one of the things I have to decide, if the weekly use has also been established, or if it's longer than that. And I know, again, a few other places like along the shore or in Maine or Cape Cod, weekly rentals are the thing. If you want to rent something for a month, you do it by 4 weeks. I don't think that's the case here in Cornwall, but that's what we're here to discuss. So the question may come down to what's customary rental period in Connecticut. And with that, I haven't confused this more than I've cleared anything up. But I think that may be the thing we have to decide, because it's clear that short-term rentals are not contemplated in the regs. And so we have to decide if they're a customary use and what, if they're an accessory use incidental to property, customary, long-standing, and widespread.
Short-term rentals or any rentals at all aren't included in the regs.
I think
correct?
that's accurate.
Yeah.
I think that we pretty much agree, I hope that long-term rentals are part of the landscape here. I think they're common, and I think their use is long-standing. People who come and rent, say, a house for an extended period of time, I think that's just done. I could be wrong, so that's one of the things that we're having to discuss.
Many people then
purchase houses.
Right, after having
Or
rented
build,
for,
and, or build.
or build, you're right.
Absolutely.
But how does this square with Perley's memo that if it is not clearly allowed, then it is not under the regulation?
Well, it's not under the regulations, he can speak to this more than I can, but there's the other things you look at, like the common usage of whether it's incidental to the property use, whether it's been associated with the primary use, and whether it has been, where there's no specific provision, and the question is to which the principal use matter of custom carries with it an incidental use, so it's a matter of law in the absence of a complete prohibition. It's deemed that the legislative intent was to include it. So I think there's certain uses that have just been accepted in practice for so long that they're just part of the landscape. But you're here, you can talk to that more than I can.
Was that a question then for me to answer relative to?
Well, I asked no,
But I'm gonna throw that to you because
Okay.
that's a good question. I just want to make sure that I was anywhere close in my answer.
Two principles are involved here. The first principle is what type of regulations do you have? Are they permissive or are they prohibited? The answer is they're permissive. What does that mean? That means unless the use is clearly allowed in the regulations, it's prohibited. Okay. The next question is, okay, well, we have to look at what's allowed in residential zones. And we look at various residential zones, which starts at 3.4.1. And uses permitted in the R1 zone are single-family dwellings. The emphasis is on the dwelling because the word single and the word family, hyphenated, is an adjective to the dwelling. Keep in mind, you're not discussing family, you're discussing uses and not structures. So, single-family dwellings together with such other structures or uses which are customarily accessory thereto. And so then the question is, well, what does that mean? And that means, under your regulations 16.3, a use or structure which is subordinate to and is used for purposes customarily incidental to those of the principal use or structure on a lot. So you have to decide when you have a single-family dwelling, are there any accessory uses that would be allowed in a single-family dwelling, such as some sort of a rental arrangement, short-term, long-term, whatever, that is customarily incidental, which is, simply put, is it a routine thing in Cornwall to allow, let's say, for example, daily rental to a non-family member without food?
Is customary necessarily mean routine?
I just use that as a analogy. It may not. You should follow the language. I tried to interpret the language by using routine. Customarily incidental would mean you look around and you say, oh yes, this is done all the time. People do this all the time. They have transient people come into their homes who do not have any food, because that's the key touchstone to this issue, in my view. Because if they prepare food, we know they're a B&B, or they're a room and board facility, which requires them to go in and ask for a permit under 8-12 or 8.12.
What about if it's a change of use as becoming a business in a residential zone? Isn't that part of the problem too?
That could be if you decided that allowing transients on a daily basis to become boarders in a house without food is okay. You could easily say that that is rises to the level of income-producing situation for the property owner. So it becomes a matter for you folks to decide, as a matter of fact, whether or not daily rental of a room in a house in Cornwall without food to up to 5 people is okay, because it's customarily incidental. And that's a question of fact, and in looking at the answer to that question, you should recall the written records that you looked at and were submitted, the oral testimony that was submitted on both sides, and you can also consider your own general knowledge of the town of Cornwall as to whether or not this use, temporary one-day rental without food in a residential zone, is customarily incidental. That was not the issue raised by Karen. I'm beyond that, because the issue raised by Karen was that because family is defined as having up to 5 people who are unrelated, that clearly allows this without the one-day use, without food, without permit. But I suppose you could find that if you wanted to, and then you would sustain Karen's decision.
Well, I would say I have done 2 short-term rentals when I had family coming here. And in fact, the first one I did was a house on Dibble Hill that belonged to Sue Boland. And I found that through Selectman Bromley, knowing that he knew so many people in town, trying to find a rental in this town around Christmas or Thanksgiving, and then you'll know how widespread these kind of rentals are, because they are harder to find than hen's teeth. So, you know, I think it is a widespread thing, and that was done, I did that rental, well, when Boland was still in town. I mean, that was 2 owners ago, before Al and Sharon Dietzel bought the house. And I also recently did another rental, the Shapiro Place in West Cornwall, again over Christmas. And, you know, it's a very competitive market if you want to get it.
You have more knowledge in this than
Well, yes, I do, and I can tell you that the Shapiro House, which is on a long dirt driveway behind my house, the address is 12A River Road, and Ira is not only a neighbor but a personal friend. He had asked me if I would handle short-term rentals for him, and I told him no, I would not, because what I'm required to do legally in real estate for a rental would take me too much time. It's not worth it, even though he's a friend. Now, I have just rented his house, effective November 1st, and I had done this 4 years ago. I now have tenants in there with a 1-year lease signed. But prior to that, what I would do, just because he was a friend, I would tell Ira, look, if you want me to give them the key, they can come to my office, and I will hand them the key, and if they need directions, I will show them how to get up to your house. But in real estate, there's too much paperwork, and I work on a commission basis, and I don't want to spend an hour doing paperwork for a commission for a weekend or 3 days. I mean, it doesn't make sense. It's a waste of my time, and it's not rewarding enough financially. So his place, which I would have to tell you if you wanted the history of it, probably he rented once or twice a month over the past 2 years, because prior to that I had people that were in there for 18 months renting on it. And he gets a stiff rent. I mean, his rent right now is $23.50 a month. And that's plus utilities and plus lawn maintenance and snow plowing and everything. So it's not cheap. The only other place that I have done short rentals for, and I haven't done less than 2 weeks, I've been working for one of the owners, one of the original families up at Yelping Hill. And I have 3 of their properties that I make available for rental in the summer. And mostly it's either 2 weeks or 4 weeks that I rent. But I haven't been successful in renting any of those 3 Yelpin Hill properties for the entire summer. And of course, once you come to mid-September, they're off the market because they don't have heat. So,
Can I ask for clarification on what you said about Ira's house?
yes,
You said for 2 years he's been doing.
the last 2 years he's had it on, he has his own website, which was called Northwest Home, I think. It was his own, it wasn't on Airbnb, it was his own website. And he got a couple of people a month. Sometimes they stay a week, sometimes stay a long weekend. Last summer, or summer before this past summer, he had a very nice couple there for 2 weeks with their 2 kids. And they came down to my office one day and they said, you know, we like it here. Is there anything for sale? And they ended up buying Gordon Ridgway's mother's house. So they're now weekenders. But that's the only time this ever happened.
Is, in your experience, and you must know the rental market because
Yeah.
you dabble in it. Is it common for rentals, week rentals? What's the most common is period rental? Do you know?
On the short term, I'm no expert. I have to think it's a 3-day weekend or a 1 week. I know earlier this year there was a funeral up in Salisbury. Somebody passed away, and the family was spread out, and there were 7 people that rented Ira's house, and they had a wonderful time, but they were just here for 2 days, and the one that I let into the house was from Vermont, somebody else was coming in from Ohio, somebody else was, you know, it was that kind of a thing. But I'm no expert on the weekends, I just happen to be familiar with his property. And he would prefer to have a long-term rental, which he now has.
Yeah. What about, Nancy, what about your experience? What was it?
Well, it was from a B&B point of view, and a B&B is generally 1, 2, 3 nights. It's usually not a long term. It's fairly expensive usually. I would say, just from my experience in Cornwall, that yes, people do rent for the summer, they rent for the year, they rent for 6 months. That I've known all my life. But I think this new thing that we have is quite different than what we were talking about rentals. I think we're talking about transient people coming for a very short period of time and changing the neighborhood from being long-term rental, if we want to rent, to very short-term transitory people. And this is where it changes the community, changes the residential area, and I think this is really what we're dealing with here. Do we want to change our residential areas to be having not known people there? If you have an accessory apartment or B&B, you have to be owner-occupied. If you're a renter, you're not going to rent to anybody that you don't know who they are and got some background on them. All you have on a B&B is a credit card. That's the only thing you have, an address. And you don't have much else on them. Mind you, you can get some recompense if they don't show up and stuff like that with a credit card. But it's because you're there that you're protecting things.
I think we ought to look at the fact that Mohawk brings a huge number of people here, and I don't think those people stay for anything more than a day or 2. You know, some people rent for the ski season, but a lot of people just want to come up for, you know.
We got a lot of
day or
Mohawk
so.
skiers all the time.
Yeah.
Yeah.
So, you know, I think, as I said, I think, you know, my 2 experiences were that it was a not uncommon thing, that it was quite a common thing.
Did you contact a number of these houses and owners to find a room for your
No, well, as I said, I started asking around town,
Or just asking
you know,
around town?
you know, asking everybody,
You know, and they said, oh, yeah, so-and-so, or,
refer me to somebody, and, you know, I found that a lot of them were booked way ahead. You know, it's like trying to get your animal into Sand Road. You better book for Christmas 2018. Don, I noticed that in the minutes for the Planning and Zoning Commission of August 11, there was a request for an accessory apartment And one of the people at that hearing had asked about whether or not the person doing the accessory apartment was going to rent it. And they said no. And it says here in the minutes, in response to the question of the property being rented, there was commission input, meaning from the P&Z Commission, that the zoning regulations do not regulate the rental of single-family residences, parentheses, including those on Airbnb, close paren. So if that's the case, and we were to rule against the enforcement decision, how would there be any enforcement?
Is that a question for me or for the group?
Well, have at it. I don't have an answer. You know, if the P&Z is saying that there are, as far as they're concerned, zoning regulations do not regulate the rental of a single-family
I
residence.
think that's accurate.
What?
I think that's accurate, they're saying.
Yeah. Well, what would, if we say that the zoning enforcement officer's decision is wrong and this is not permitted, what would be enforced?
We'd have to get special permits.
Right.
They'd have to get
Yeah.
special permits. The people that wanted to rent short-term would get
So
special
you
permits.
say that the ability to, so all renters in town then would have to get special permits? Anybody renting for a year, a month,
No, I think.
6 months would have to get a special permit,
I guess
right?
I think you look back in the other parts of the regulation about uses that are permitted by right and uses that are permitted because they're accessory, uses that are permitted because of long-standing custom uses.
Yeah.
So not necessarily you're not going to close down all rentals.
I think the commonality has been long-term rentals. I think the new thing is all these Airbnb. I think there's quite a difference between them, what we're looking at here.
Yeah,
I don't know, I think the danger is that we're making a decision based on the fact that a lot of people don't like Airbnb, and that the impact would not be on Airbnb, but it would be on everybody in this town who rents.
Oh, I don't agree with that, Joanne. I don't.
How do you not agree with it when the zoning commission says you do not regulate the rental of single-family residences? You can disagree, I can disagree, but they're saying there are no regulations. I mean, if this board, whatever we decide, I mean, maybe you're saying the real decision needs to be made at P&Z, which personally is what I believe, but I mean, that doesn't mean that we should make a mistake or do a wrong decision that could be.
No, it's our job to interpret, it's their job to make policy. And-
Well, they're saying there is no policy.
Well, then, it's their job, if they determine that there needs to be policy, they make it. It's our job to interpret the policies that exist.
Is it in any way our job to suggest that they make a policy? Request them to do so?
We could suggest that they look at it, we can suggest that they clarify. Yeah, we can do that.
I know we're just Cornwall, not the state of Connecticut, but the state does say anything a month and over is a rental. That's how they determine it. And I think that has some common sense behind it.
I do too, actually.
So are we therefore being asked to decide what is customary tonight? Is customary a month? Is customary 6 months, a year, a summer of 2 weeks?
I think that's a good part of it, yeah.
Remember that you are here on an appeal from local folks who went through the process of asking the zoning enforcement officer to look at this on a very narrow basis. And the narrow basis was initially a B&B concept, but then Karen found, and I think told this board, that people who are not serving food are not within 812. And I think that's probably correct. And so then the question is, okay, one night's rental of a room in a residence without food, for money, is that something that is customarily incidental to residential properties in Cornwall? Do all of you do it? In other words, in the memo, there's the case that I cited, which is the Lawrence versus Zoning Board of Appeals case down in North Branford, which says that customarily places a duty on the board to determine whether it is usual to maintain the use in question in connection with the primary use of land. I had said routine. I should have said usual. So, is it usual to allow this? I don't think that the applicant was getting to the level of monthly rentals, because in monthly rental, it's a longer term. I think the applicant was in the inn business, and he was looking at this as affecting the inn business, which is night to night, in effect. So the issue then becomes, is it, in your view, based on the facts that you find, customarily and usual to maintain for people to rent out rooms for 1 day or 2 days or 3 days? These are renting out rooms without food to transient people. Is that what residences customarily do in Cornwall?
If we decide this issue on the basis of custom, and what's customarily done, then that would imply that any new business practice that came to the town could be judged not customary and not accepted. Is that so?
That's true. Each one is a factual determination as to what's customary. Remember, we're only dealing with the residential zones and the fact that single-family dwellings are allowed together with such other customary uses as an accessory there too. So,
And there might be, when other people come to town and want to do something, that those uses might be allowed in the regs. We're talking, you know, pretty narrowly defined here, the rental of residential property.
if the person wanted to have a barber shop, we think we would find that that's not usual in a residence, and permits would be required.
Just because it's not usual or not customary, doesn't mean it can't be done. It may be that, you know, permission must be sought and permits granted and things like that.
Well, if I may say something, I think this is a relatively new phenomenon, this whole Airbnb thing. And so it's new to all of us. I think from what I've learned, sitting here and hearing other people speak, there are probably about a dozen property owners in Cornwall that are renting out rooms this way. They're not B&Bs, they are not providing any food, and they are not present when their home is being rented in this way. And I can't find that our land officer was in error when she said that it was okay to do that. I mean, I'm not aware of a rule that says you can't do that.
Well, the regulations are not prohibitive, they're permissive, and that means unless you can find a rule in your regulation that allows it, it's prohibited. So,
Except if it's customary and common and, you know,
well,
long-standing, right?
the reason that I raise that is because section 3.4.1 of your regulations says uses permitted in the R1 zone, which is in the same with all the other R1 zones, which are single-family dwellings, together with such other uses which are accessory thereto, and then you turn to your definition of accessory, and they use the same language that has traditionally been used throughout, and is traditionally used in cases, which is subordinate to and used for a purpose customarily incidental to those of the principal user or structure on the lot. So that, the framework of your definition is within the framework of the case law in the state of Connecticut, which I referred to the Lawrence versus Zoning Board of Appeals case. This hearing that we have, and your rights as a zoning board are de novo. That means that you are acting from the beginning, and you can find that the ZEO decision, interpretation of family was correct, and sustained it on that basis, and that's the end of the discussion. That's the first thing that you have to think about. But if you find that that decision is not correct, then you would look further to your regulations. Is there anything else in here? Because you're now sitting in the same chair that the ZEO sat in when the applicant brought in the application for these things. So what are you going to decide? Well, you're going to look at the regulations and you're going to see, well, what about 3.4.1, which talks about uses which are accessory to residential uses. What about accessory uses? Is a daily use of a room, rental of a room without food in a residence in Cornwall, usual, customarily incidental to the residential use? That's a factual determination that this board has to make. And of course, when you make a factual determination, you have to have substantial evidence, the cases say, to support that conclusion. And so you should be careful about that when you think about making a decision on the customarily incidental use, to be sure that you are making it on the right basis. I've heard people say a month is fine. I suspect, I know for a fact in other towns, down on like Warren, for example, all you have to do is read some of the real estate brochures to see that you can pay tens of thousands of dollars to rent a house on Lake Warnock for a month in the summer. Now, that's Washington or Warren, that's not Cornwall. But you should ask yourself, does that occur in Cornwall? And if monthly rentals are customarily incidental to a residential use, then you say, okay, monthly's okay, but not daily. You have that ability to fashion your decision to fit what you find to be customarily incidental to a residential use in Cornwall.
How does something become customary? It has to start from somewhere. So the first person who rented on a monthly basis was doing something that was not permitted.
Yes.
That's why I asked that.
Yeah, I know, referring back to what Ann was talking about.
Yeah, that would be correct. That would be correct. But a lot of those...
It might have predated zoning though, and it therefore would be grandfathered. If we were looking at it that way, it's not necessarily that it was wrong when they did it, it just there was nothing in place. I mean, I would believe that rentals in Cornwall go back prior to zoning.
We had boarding houses, a lot of boarding houses. John's grandfather had a boarding house.
Well, those were different, but I mean, so it's not necessarily that someone was doing something criminal or wrong when they did it. I mean, it's, so customary could just be what you said it is, customary.
Well, I think, customary brings the definition of whether it is usual to maintain the use in question in connection with the primary use of the land. Is it usual to do this in Cornwall? That's a factual determination. And that includes, on the factual determination side, the issue of length of stay, in my opinion.
Also note that Torrington Area Health said in their thing that they will not be registering Airbnb as they are currently viewed in the opinion of Torrington Area Health as rental agreements between tenants and landlords and are exempt from licensing.
That would be the licensing allowed by the Torrington Area
Done
Health
by
District,
Torrington Area Health.
which
But it's
takes care of the public health code, but it's
Yeah.
unrelated to your own regulations. They don't enforce your regulations. or it doesn't mean.
Right, but it was something that was brought up by the Cornwall Inn people about the burdens that they encountered because of Torrington Area Health. That was a large part of their initial testimony, was how burdened and unfair they thought things were.
Well, I think that the Torrington Area Health does have a role if the use falls into the 812 category, right?
Right.
Which is a good thing because you have food being served and it's a public health issue.
Right.
And hence Torrington Area Health and your regulations say that they must weigh in on the subject when the person comes in for an application.
Yeah, but I think we should be aware of the fact that a lot of the reaction in town that was ginned up was done based on incorrect information of comparing them to the Airbnb rentals.
I
They
think
were
our-
not the same thing.
I think our job is more, I think Airbnb or other businesses like that may have been the catalyst for this, but I think we are limited and should be limited to looking at our regs and our usage and our customs and what we do here and what the regs say we can do and what's prohibited. I don't think what Airbnb is advertising or doing really comes into play. Obviously, we're aware of it, but I think we have to focus our attention on what's written before us and what the customary usage of the properties are.
I just want to say that I don't think it's a hardship to get a special permit. It's not a difficulty, and the things that are required are things that we really all want to see. It's for the safety of the people coming here. It's got to do with parking, it would be septic, it's all the things that zoning covers. There's a broad spectrum. They're saying, we want to make sure if you have people coming in, that these things are in place. That's not a hard, don't we all want to support zoning that way? That's not a hard thing. Look at the regs for a special, for B&B special permit. They're not that difficult. I mean, any one of those people could get them. This is an aside, it has nothing to do with our meeting right now, but there's a 15% state hospitality tax. And I'm sorry, but I think a lot of people are just trying to avoid that, because if you're not registered with the town as a B&B, you can avoid that very easily by just not paying it. That's not our
Any
reality.
contractor getting cash can do the same thing.
That's right, that's right. But I think this Airbnb is anybody that wants to do Airbnb can get a special permit too. It's not that difficult, if we can do it.
I also wanted to add to that, Nancy, because the Connecticut State zoning regulations state that in section 8-6, the powers and duties of the ZBA, with due consideration for conserving the public health, safety, convenience, welfare, and property values. And I think that this is a very important responsibility as we look at a changing landscape of lodging opportunities for employment, for extra income, that we really need to look very carefully at the regulations and around safety, special permits for people who want to have income from renting their property. I think it protects the town, it protects neighbors, it protects property values, and I would feel myself not doing my duty as a member of this board if I didn't really consider all of those factors.
But Amy, how would you differentiate that from a monthly rental? Don't we have to be concerned about the same things?
I think we need to be concerned about the customary and usual. Across this town and I won't say nation, but we know it, individuals and couples and families rent on a long-term basis, until they move or find a property they can afford to buy and stay in the community. As far as a 1 month, just 1 month, let's come here, my family is here, this house We know someone's leaving for a month, we're gonna stay here for a month. I think that if the house, and it's 1 month only, we need to talk, that needs to be discussed. But it's short-term, it's transient in a way. We need to look at that. And I think the zoning board really needs to sit down and hammer a lot of this out. Because I think people have a right to earn a living and augment their income. But within the regulations and by a special permit, and those are gonna have to be really reviewed, in my opinion. It's a sticky issue, as we know.
But then, are you saying that we need to refer this to the planning and zoning department?
I think what we need to do is make a vote and determine what our vote will be to this appeal, and then make a strong recommendation to planning and zoning and the first selectman to take our regulations and review them, given this changing landscape and the health and safety and welfare of people in this community and those people coming through, traveling through.
I think if we vote to affirm the zoning enforcement officer's decision, I think that's the end of it. I think that if we vote to overturn, or reverse, I guess the proper word, then we have to decide what the remedy will be, and the recommendation to maybe put it back to Karen with some direction to her, or I don't think it's a remand to the P&Z because
No.
it didn't come from P&Z. This was an action taken against Karen's decision. But I think if we vote to affirm, I think we're done. I think if we vote to reverse, then we're freer to direct or recommend to either the zoning board or to the ZEO.
I would ask council to comment on that. Is there any difference in our ability to refer actions depending on which way we rule?
You have the right to fashion the remedy if you decide to reverse the decision.
And
That means create the remedy. You could say that it's our finding that there was error in respect to all rentals of less than a week, or all rentals of less than a month. And you could leave it at that.
Okay.
And then you could come back to say, and we further ask that the Planning and Zoning Commission look at the whole rental question for terms longer than that. And if the zoning commission wants to look at new regulations for daily rentals, they can do that. We're
so
only
really, there is no difference which way we rule in terms of our ability to cause a remedy, which will eventually come from P&Z, not from this board.
well, no, because if you affirm, then it's a fait accompli that Karen's decision stands.
But P&Z can still consider doing anything they want, and we
They-
can still make a
they-
recommendation to them if they do something, right?
They could, and then they could change the regulation, and then those people who got in under the wire and did this before the regulation changed would say, I'm grandfathered because I did this daily rental for 6 months before the regulations got changed, so they'd be grandfathered.
Okay, but we also know that in the second hearing that we had, that the Cornwall Inn people added people beyond the first list. So the first list is actually quite short between the people who got off the list and that list. So it's not the long list of people that they
Right, and one of the things you should think about is, do you want to get down and look at each property that was looked at by, that was brought to Karen's attention back in January, you looked exhaustively at Karen afterwards, and then go through that on a property by property basis? And I agree with you, there are, I believe, 5 properties raised by the Hampsons that were not given to Karen to review, okay? But there are 15 properties that were given to Karen to review, and you heard her response and you saw the review that she made. So we can't do anything about those other 5 properties because Karen never had a chance to look at them. They were never before her. So that's too late in terms of this particular issue. But the concept that I have and think that you ought to think about is, A, your regulations are permissive. Only uses that are clearly allowed are permitted. It's not where we look around and we say, well, there's no prohibition, I can do this. Think about that if that were the case for all of your residents, for all of the uses that you can ever think about. Well, I'm going to do whatever I want because it's not prohibited. The regulation is intended to be permissive. It's intended to say you can find a allowed use in the regulations, you can have it, but don't come in here and say, I can do anything that's not prohibited. That does not the way it works. So these are permissive regulations. They must be clearly permitted in order for the use to go forward. That's the first step. And then we look around, and the next step is, okay, do we agree that the word family, as interpreted by Karen and her attorney's memo, allows this use without food for up to 5 days? And then if you say no to that, then the only question gets to the next issue, which is what I point out, because I went through the regulations and looked and said, is there any conceivable way that under these regulations this daily rental could come into play? And the answer is, I suppose, if it's customarily incidental, yes, it's an accessory use. But that's for you folks to decide on a factual basis. And it's clear that your regulations are permissive because it says that in section 3.2, and it also says it again in section 16.2. Uses of land, buildings, or structures not clearly permitted in the various zones are prohibited.
So how do we decide tonight exactly what amount of time is customary?
I guess we talk among ourselves and just see what's been done in Cornwall for long stretches of time, and what I guess that's one of the definitions of customary is time honored, I suppose, and it's got to be also connected with the primary purpose of the property. But, that's, I think, pretty much taken care of with because of the fact that long-term rentals certainly are permitted. So I guess we've just got to determine what amount of time is customarily allowed here.
Another thing I see possibly happening as a result of our decision, say we were to affirm Karen's ruling, then I see there would be nobody in town getting a B&B permit. Why would they? They'd say, pooh, I can do without it, and I don't have to tell anybody I'm doing food. I'm not telling anybody I'm doing taxes, I'm not telling anybody I'm doing anything. It would erode the whole basis for which we have special permits. I think that's sort of the danger of going that direction.
But they couldn't have more than 3 rooms.
How would you know? They don't have a special permit.
Well, how are you going to know? I mean, okay, Lisa Nicholson is here all summer. She leaves, she goes back to Antigua. All right, Christmas comes, and there is family there, and they're skiing and they're doing things. Do we expect Karen to go up and knock on the door and say, are you paying rent? How long are you here for? I mean, the enforcement possibilities. And I also, the question of property values, which you brought up in reading about the state statute and our responsibility, I think one of the things, and we also need to look at the plan of conservation and development. And if you've been going to P&Z meetings, they're very concerned about affordability and making, affordability to me is not just building affordable housing that's subsidized. Affordability is making houses that people have that want to stay in them or buy them, having a supplementary income. And when we remove an as right And I think most people buy a house, and I don't know, Priscilla, you'd have to address this, but most people think that they have certain rights. And P&Z always laugh because everybody thinks they can do anything they want till they go to do it. And then they show up at P&Z and they find out that they really can't do most things that they think they can do. I think that people buy a house and think that there are a lot of things that they can do. And we have to remember, we are a tiny little hamlet. And when we prohibit something, I mean, it was like the example you gave the other night about the cost of septic systems in Cornwall versus Sharon. People make decisions based on taxes and regulations. There's no doubt about it. I say we are stealing from the people in this town, taking money out of their pockets by decreasing the value of their homes when we put limitations on what they can do with their homes. I think that's the flip side of the concern that this board should consider.
Well, there are a lot of legal cases now with Airbnb, and they're spending $8 million in San Francisco to fight this.
But as Don said, we are not discussing Airbnb.
Well, I'm talking property values from that point of view. And the opposite side of Airbnb is saying, look, you're eroding our property values here. You're having short-term rentals in a residential area, and those property values, that's what they're being fought about.
And a lot of those issues are in condos in New York or co-ops in San Francisco and things like that. I mean, I think it's really different. But I mean, I feel we have to consider the fact that we are sticking a vacuum into the pockets of people in this community and sucking money out of it when we limit what people can do with their property.
We're not limiting it, we're just asking to get a permit. That's not limiting it. It's saying, go by the rules that everybody else goes by. Fair is fair.
Everybody else. It's
The
not
other
everybody
people
else.
that
It's
live
what I
in
mean.
Cornwall.
The original setup of comparison of the Cornwall Inn to a residence is not an apple-to-apple comparison.
Okay, I'll take one comparison as a B&B, former B&B. If somebody next door to me has a B&B but doesn't go by any of the regulations, why should I bother? It just erodes planning and zoning.
If they operate as a B&B, then you can report them and they will be.
That is exactly how they will be enforced. They will be reported. They will be advertising and they will be
Karen
reported.
found that she investigated and none of these people were in violation.
According to Karen, that is our decision tonight, whether they were in violation or not. We have to decide whether we want transient people in the residential areas.
There's another question too about the whole issue of special permit. Because Cornwall raised the question of safety inspections. Nothing appears to be in special permit under safety inspections. If I rent my house for a month and I have unclimbable stairs, that would not be part of would not be inspected and that would not be known.
Right.
And another thing, we have quite a few of the residents of Cornwall are weekenders. And some of our weekenders are more seasonal than others. And so this is another way that those homeowners defray their personal expenses. It makes it easy for somebody who likes to be in Cornwall for the summer season, go to the lake, and have no interest in being here for the ski season, to do the transient rentals because they know that there is an audience for Mohawk. So when you talk about people losing jobs and businesses being pressed for money, I think that some of our homeowners who are looking for short-term rentals really need the income. Or they're going to have to sell the house or, do something else.
And you don't think they could get a special permit?
I don't understand why they would need a special permit just to let a house. I do understand it if they're providing a bed and breakfast situation or any kind of food. But just to rent a house for a weekend or a week or a month, no, I don't think it does. I don't think you need to pay an occupancy tax for that.
I see.
Because I don't view it as a business.
If you're exchanging money, it's a business.
No. You're not doing business every time you change, exchange money. That's not a definition of business.
It's a service and a good, goods and services. I mean, you're providing a room and access to that for sleeping and safety, and you're exchanging, that's a business.
It's not a business. When you're renting out your house, it's not a business. I'm a lifetime renter who has finally bought land and built their own house, so my life has changed, but, for 60 years, I've been renting in different places for sometimes a month, sometimes 2 weeks, and that's how I started here in Cornwall, just doing a couple of weeks. And so, I know the advantage of having a place for a very short period of time. And my problem with this decision tonight is if we're going to regulate some rentals but not others, how do we decide, it's a slippery slope. If you start regulating something, what else might be regulated? And how do you determine, and it's the question I asked before, how do you determine what's customary? Do we really make such an important decision based on what's customary? Or do we make a decision based on what's right? And that, of course, is something that we come out of discussion.
I think we make it based on what we interpret the regs to be, and they're using the words customary, and
But we use discretion.
we use discretion, right. But I think we determine that based on what is customary and accepted usage not usage, but definition of those terms in Cornwall. And I think it does come back to, we have to make some sort of decision about the time period. What's customary in Cornwall is renting by the week, by the month, by the year. I think we do have to make that decision.
Don, could you phrase the question, or could you say the question really is whether homeowners should be permitted to rent?
The regulations, I think, are pretty clear that they're not, because it's not in the regs, so we have to look at other places, and there are times where I think they are permitted to rent, and there are times when they're not. And I think one of the reasons, or not reasons, but one of the things to look at is the customary time period that people rent for. So I guess it gets back to, I think, determining a time period that is customary for people to rent their homes.
So you would agree then it is customary to rent in Cornwall?
I think
It's
so.
just a question of whether it's customary to rent for more or less than a specific time frame. Is that what you're saying?
Oh, I think it's customary to rent here. I think a lot of people, including myself, came to Cornwall and started as renters.
And the
So
second
there'll
part of your
be-
question, Joanne, was what?
Well,
It's customary to rent, but
well, my question was, is if it's customary to rent, then the only question is a time frame. So, I mean, I don't know how you could possibly. I mean, if you say it's customary to rent, it would seem to me that, can I put it on Airbnb? So it's okay to be on Airbnb as long as I say it's for a month,
No.
if that's what you agreed to, if that's the time frame you agreed to.
Well, if you're doing a bed and breakfast, there's a different set of rules.
No, I'm not doing a bed and breakfast. If we're talking about this decision about renting, we're not talking about a bed and breakfast, we're just talking about in a house, right?
which I can advertise on Airbnb.
Oh,
Yeah. Right?
The name is confusing because it's not really Airbnb necessarily.
Yeah. So this is really about changing the rental market in our town.
I don't see it as changing the rental market. I see it as they would still have those opportunities, but I would like to see regs in place for the safety and welfare of these people.
But a special permit has nothing to do with safety. Absolutely nothing in our regs say safety.
I think it does when you talk about the septic, when you're talking about being up to code with the septic system with a B&B, that's a health and safety issue.
Yeah, that's in a B&B, but if in
Well,
a house, it's,
but-
Torrington Area
but I
Health says
think-
they wouldn't do
but
that.
Doesn't it, the house have to be safe and sound?
Yes.
That's
You-
paragraph 3 in section
Yes,
8.1.
safe and
Well,
sound.
Yeah.
and it's clear.
You are expected, there's no question.
Yeah.
But Torrington Area Health says that's not. I mean, well, what about your house? Well, I'm worried about Jamie. I'm gonna send Torrington Area Health over to your place, and I wanna be sure that everything's okay.
Well, you could certainly try and do that,
Yeah.
but I'm not, you know, and I can say, well, wait a minute, here, this is private property, and I'm not using it to augment income. And I will tell you, I have a space, I've thought about it, and I thought, I am not gonna do that because I'd have to have special permits and be up to code and all of it. And I didn't want to do that by
The only
choice.
code is that the septic is sufficient for the number of bedrooms that you have.
But you do have to, my understanding with Torrington Health, that if you're serving food, i.e.
But we're not serving food.
But in a
We're
bed
not.
and breakfast.
We're not,
Yeah, but that's
Not
not.
talking
I
about
know,
that.
but that's in there.
I think we're getting bogged down in time frame and commonality, and I think the whole broader issue is what Pearlie keeps talking about, is that if it's clearly permitted, if it's not clearly permitted, it's prohibited. I mean, I think that's just,
except if it's customary and long-standing.
but that becomes so judgmental then. We all say that Cornwall rents. Well, I don't think you can do a time frame that easily unless you want to go to the state of Connecticut or something. I think that bogs us down. I think we've got to say that it's not in the regs as they stand now. And then recommend P&Z address this.
Yeah.
And then that's an overview of everything. We've stuck exactly to what they've said. And say, P&Z, you've got to address this because there is not an easy answer for this case.
There is not.
Well, if they say, P&C says we do not regulate the rental of single-family residences, that's what we're talking about. So now we're telling them that they should.
Yes,
Yeah.
exactly what we're telling
We
you.
can tell them that they should and still support this decision, because this decision now, I believe the way it stands, does reflect the customary and long-standing practices of this community. And that we, as the zoning board of appeals, should not be writing regulations for the rest of town. That's what we elect P&Z.
That's,
Yeah,
This is not a question for you to legislate, this is a question for you to interpret. okay?
Right.
That's what you're doing here. There are other legislators out there, they're called the Planning and Zoning Commission.
Right.
They make the rules.
And it should go to them.
Right, well, the issue that you have to get to first, if I go back to this, is as set forth in Mr. Herbst's memo. Karen interprets that regulation to allow use of the word family, if you look at Mr. Herbst's memo, to allow rental of rooms in a dwelling to unrelated individuals not to exceed 5, provided there is no room and board furnished, furnishing of meals, and there is no bed and breakfast, furnishing of breakfast. So we are first going to have to decide if that interpretation is correct or not. That's what you have to decide, based upon the use of the word family. Then you say, okay, I think we're beyond that. I don't know, but you should probably make that determination first before we get into more discussion about length of terms and customarily incidental. If you agree that Karen's interpretation is correct, as set forth by her attorney, and as testified to by her, then you affirm her decision, and that's the end of it. But if you don't find that, then you have to go to the regulations and say, okay, where in the regulations is this allowed? Where is it clearly permitted to do this on a daily basis without food?
And it's not clearly permitted.
Well, you can read the regulations, it says that as well as I. Now, unless, then this is where we get back to the next question, we're on the third question now, is it captured within the accessory use definition, customarily incidental? That's the only way I could see that it could be so interpreted to allow it. And that gets down to the question of your common knowledge, and is it usual in Cornwall to do what Karen interpreted to be done, which is to allow rental of rooms in a dwelling to unrelated individuals not to exceed 5, provided there is no room and board furnished and no bed and breakfast. Is that customarily incidental? Or you could say, well, I think she's right. Within the definition of family, that allows it. But you have to get that question behind you first. And then you say, okay, what other areas in these regulations might allow this if you want to look at it that way?
I need a clarification about the family thing. Karen may have interpreted it on the basis of family.
Mm-hmm.
Do we have to interpret it as being an incorrect decision based on the fact that she says it was about family, or can we decide that it was the right decision even though she may have given a slightly a reason that we don't totally agree with?
You have the right to do a de novo hearing and interpret the regulations and make your decision. And if you found that her family definition was fine, then as I said, you would affirm her decision and we'd all leave. If you find that that's not something, then you create your own order. You are acting now in interpreting these regs as the CEO, and you're trying to decide whether it's allowed in the regulations when these regulations are permissive.
Well, why does Peter say in his memo that there is nothing in the regulations that prohibit the letting of a room where there is no board and there is no B&B establishment? I mean, of course, I understand that's what you guys get paid for, is to take opposite sides of the situation. But please explain to me why he said that.
I cannot explain to you why he said that. You'd have to ask him.
But
my opinion is.
Well, your opinion is the next statement.
Right.
While that may be a true statement, the fact that there is no such prohibition does not mean that renting rooms are allowed or permitted by the regulations.
Exactly. Because
That's the counter.
that's exactly right. You hit on it. That's my opinion.
That's your
You
opinion.
you can't go through the regulations and say, well, it's not prohibited, so I can do it. You got to find something in the regulations that allows the use in Cornwall, because they're permissive regulations, and if it's not clearly permitted, it's prohibited.
I think it would have been helpful if we had some of your insights before the hearing closed, so that the board would have had a chance to question Karen's attorney more effectively.
No one asked me for that.
Well, that's, shame on us, okay? But I think that's something we should consider in the future, so that we have a better ability to make judgments. Because now we're so...
And then you go down, and this is where I'm wiggling through. The only possible claim, I'm still on the same page, could be that such letting of rooms for a fee on a transient basis is a valid accessory use to a residential dwelling. However, neither the CEO nor Mr. Hurt has claimed that that is the case. Doesn't mean that we couldn't.
Right.
That's true.
Okay.
I just point that out for you.
For our edification. Thank you very much.
You're welcome. Because you're acting de novo. You're the second, Karen, you're the second CEO is looking at this on a clean slate basis.
So if we were to decide that, we're not overruling Karen's decision.
That's
We're
right.
just giving a different reason for it.
Well, you would reverse that portion of her decision that relies on the definition of family, and you would find that it is permitted
Got
as an accessory use under a residential zone. If you want to further get to the point, then you would say, for a term not less than a month, not less than whatever you wanted to say, if you so found that.
But we would not have to put a time frame in there. We could leave that to P and Z, right?
Well, if you did not put a time frame in there, then you would have done nothing different from the result that you reversed Karen's decision on. Because then there would be no time frame. And so the issue is an accessory use. I read Karen's information, I read Mr. Herbst's interpretation, and I said, well, as a matter of fact, the thought occurred to me when he said that it's not prohibited, so we can do it. I said, that's not right, in my opinion. And so let's go in the regulations and look in the regulations and see if there's another space where it might fall. And the only space where it might fall, in my opinion, is as an accessory use to a residential dwelling. And then the question, and Karen's memo is quite clear in terms of the room and the no food.
But it could also fall within the guidelines of our plan of conservation and development.
I don't think you're sitting
In
here.
terms of the goal.
Well, I think the goal is not something that you look at when you enforce the regulation. The goal is such a different topic under the POCAD, Plan of Conservation and Development, that it is more philosophical or policy driven. It's not day-to-day administration of your lives in Cornwall based upon a set of regulations. POCADs are designed for planning purposes, going forward purposes, what can we do to assist the town, that type of thing.
But it could reinforce the customary and, existing mindset. If we were looking at it as being customarily done, and that it would be supportive of that idea.
I don't think that would be a fact that would be reasonably related to the conclusion that it's customarily incidental, just because the POCAD says that. I don't think that would be substantial evidence.
So do we need a motion?
I think it's about time.
And the first motion has to be about the family.
Should be. Yep.
Are you about to make a motion or?
No, I just was asking if we did. I'm not sure where we'd be yet, I'm thinking. If anybody else can come up with one quicker. I would need help with the language.
You can do it. What is your intent?
I want to have us vote on whether or not Karen's interpretation is correct to, that we could allow rental of rooms in a dwelling to unrelated individuals not to exceed 5, provided there's no room for B&B. Do I need to make the motions on one side or the other of that, or can I just move that we go to a vote on that?
I think you either need to move to affirm or to reverse on that narrow issue.
Doesn't matter which way, because you're gonna vote on it, so it doesn't matter which way you state it, really.
Well, it does, because it gives my opinion when I state it, and I'm not sure that I'm ready to do that.
Well, as chairman, I'll make the motion.
Okay.
I vote that we reverse on that narrow issue of the definition, that
To reverse,
one. Karen's decision on that narrow issue. One more preliminary issue.
on the family.
You said it better than I did.
You can just take it out of the,
Out of
it's
Furley's.
a rate to allow rental of rooms
Right.
in the dwelling. It's on the second page.
So you want to go with that exact language, John?
Yeah.
Which one is that?
Actually, it comes from Mr. Hurst's last sentence in his second portion of his memo entitled "Rental of a portion of a house / a room," where he says, Karen interprets.
At the very first page.
This one, Karen interprets,
That the regulations to
allow the rental of rooms in the dwelling to unrelated individuals not to exceed 5, provided there is no room and board furnishing of meals, and there's no bed and breakfast furnishing of breakfast. Okay. Okay.
We'll give that back to you.
Okay, great.
So, we need a second,
We
right?
need a second.
Could
I'll
you
second.
read that?
Would you read it again?
I'll read it.
Okay. So Don made the motion to reverse Karen's decision for the interpretation.
Based upon her definition of family, but based upon the definition of family.
Based on
The regulation.
Right.
family.
To allow,
That regulations allows rental of rooms in the dwelling to unrelated individuals not to exceed 5, provided there is no room and board furnishing of meals, and there is no bed and breakfast furnishing of breakfast.
I'll second that.
Is there discussion? Then let's call a vote. All in favor?
Aye.
Opposed?
6 in favor?
Now, could we move to permit the rental based on customary and long-standing practices in Cornwall?
You have,
Because you reversed on one very narrow, as you pointed out, one. Could you now support the idea of allowing homeowners to continue to rent?
as we have been discussing, the zoning regulations for residential zones permit as of right a single-family dwelling. It refers to uses permitted in the zone. So a single-family dwelling together with other such uses which are accessory thereto. So you would then have to find, if you wanted to, in your discussion, that some length of time is incidental, we allow.
Yeah.
And you could say daily, you could say weekly, you could say weekends. You would have to get back to the fact-finding issue for the town of Cornwall as to what's customarily incidental or usual. And if you say, you know, we, however, find that rental of dwellings is permitted in Cornwall, provided it's for a term of not less than 30 days or a month, is acceptable, then that would be your interpretation of your regulations.
Can I make a motion to that effect if you'll say it properly?
So the motion, well, I don't usually make motions.
No, but, the motion is made by, Nancy made the motion, but I think, am I right, you wanted some clarification of
The,
The language, you mean?
yes.
I think the language might be that the board finds that an accessory use of rental of a dwelling for a period of time, not less than a month, is an accessory use in Cornwall.
I think that's too restrictive.
That's where we get back to the discussion.
Right.
I'm not making any motions, I think.
the motion's been made, is there a second?
Second.
Then I guess, now we can discuss.
I think requiring a 1-month rental is excessive. So I would want to make a different motion. No, I can't do that, I realize that, but
That's what we're discussing.
my statement is, I think that people should be allowed to rent for a week.
Okay, well, I think that the question is, not whether people should be allowed to rent for a week. No, don't necessarily disagree with that, but I think the question is what's the custom here? What's done here, not what's right or wrong?
Well, I think you have had some experience in town with people, I don't know how many, I don't know if anyone's ever kept track of this, but there have been quite a few weekend rentals at different times of the year. I'm aware half a dozen or so in my backyard. And I think that many people travel, they're transient, and they like to stay in different places for 2 or 3 days. I also think that there are many people that could afford, they'd pay the rent for the week and leave when they go on World Peace. There's no regulation against that.
But you're thinking of the week as the smallest.
Well, I'm
That's
going to
what
see
you
it.
said.
I have to say, being in real estate, the fewer regulations on a house, the better, I feel. That's a personal, professional opinion. But I understand this is a very sensitive issue with many other zingers on it. But I don't like having to hear that there are lots of restrictions. I do think that our planning and zoning regs could be a little more clearly stated, but that's all I'm saying. I think to say a month is restrictive, too restrictive, in my opinion.
Anybody else?
I would concur with that. I don't know the right time is, but I would agree that it's very restrictive.
It may be restrictive, so I'm looking, trying to determine what is commonly done here. I'm not saying you're wrong, I don't know of any weekly rentals, but I know a lot of monthly rentals.
No, I don't have a sense. What are the facts regarding that kind of a term? You know, we certainly are hearing more and more about weekends, 3 days. and in some instances, a week. But are there a number of houses that are rented for, a month?
And
Or, I just don't know.
when I read in the materials, when it said like common usage, it means overwhelmingly, used in that way, not just a few people here and there. And again, I'm not saying that you're wrong here, it's just
Yeah,
my own feeling for this is that most people rent monthly instead of weekly.
But we don't have the data.
We don't.
No,
We don't.
but I think most homeowners are really, as you say, would rather rent for a month than they would, because they know that person's gonna take a little bit better care of the place than people coming in as a more transient basis.
Well, I think that's an assumption you can't make.
Well,
I mean, if you rent for a month to, a bunch of college kids, forget that argument. I mean, I think it's more, a lot of people traveling for 1 or 2 days are people like me. I'm going to a party up in Pittsfield, I don't want to drive home at night, so I go to a bed and breakfast for one night. I am going to a bed and breakfast. I am not going to an Airbnb place.
Which should be regulated and permitted.
but I have nothing against
I-
rentals, and I've got nothing against Airbnb, anything. I think we've got to distinguish between the transient population and that is more permanent. And I think we start with a month and then see how it goes. I mean, this is something that's,
Why not start with 3 days and see how it goes, and then I'll.
because that's very transient. I mean, that changes the whole neighborhood then. And that is definitely,
Please point.
with the overall thing of clearly, if it's not clearly permitted, and they did take into account B&B, so they were thinking along those terms, so they wouldn't have put B&B in at all.
How many years ago was that? I mean,
But it's
these are
still the
new
regulations
terms.
we're working with. Those are our regulations we have to look at. It's not clearly permitted. And B&B was considered, and there were regulations made for them. And that's transient, and that's what they were looking at. Rentals are different, they're not transient.
Well, are we ready to vote? All those in favor of Nancy's motion? Aye. Aye. That's 4. All opposed?
Nay.
2.
Okay,
Motion
so
carries.
who's nay?
So,
Betty and
Nancy, in favor?
Yes.
Mhm.
So that's fine.
Motion carries.
The only other thought that I had would be, if you had discussed before, whether you wanted to make any reference to the Planning and Zoning Commission regarding looking at this whole issue. That would not be something that would be binding on them, just as what they say is not binding on you, but you may want to say a request would be made to have the regulations looked at on this subject.
So moved.
I would love that.
Yes.
But that's a request.
Recommended planning and zoning look at the rental issue in town.
Yes. So it's the board, just the board's gonna recommend?
Right,
Request.
unanimous.
Yes.
It's a request.
Yeah.
Recommend, I think, is a little too presumptuous. We respectfully request.
and what advice do we now give to Karen for enforcing this?
Anything less than a month is, unless it has a B&B permit, if someone were to take a house without food for a month, then they would be in violation of the interpretation that was
And
approved.
how do we report this? How does she do this?
In the normal course of enforcement, it's always a question of, I won't say boots on the ground, but it's a question of neighbors and observations.
Ratting out your neighbors, is that what we're doing?
You
You
check
could call
my
it.
septic system or my house.
No, you want to do it for everybody else.
Is there anything else for that?
I don't have anything further.
Then,
Thank you very much for all your help.
yes,
You're welcome.
I will say this, I think it should be on the record that Attorney Grimes was very helpful to me, and he walked his fine line of not telling us how to vote, but giving guidance, and I think is invaluable to me in the last
Willie, can we request that next time we have you here that we get your opinion right up front?
Yes.
I'll entertain a motion to adjourn.
So moved.
No one's going to be opposed to this, so.
Are you gonna do your minutes?
Oh, right.